and welcome to the 107th Sibley Lecture at the University of Georgia Law School. My name is Rebecca White, and I'm the Dean of the School of Law. This lengthy and distinguished history of the Sibley Lecture series stretches back more than 4 decades. The first Sibley Lecture was delivered 46 years ago when Yale Law School professor Miles McDougall spoke on jurisprudence in a free society. Since that time, such well-known judges as Chief Justice Earl Warren, Justices Harry Blackmun, Antonin Scalia, and Ruth Bader Ginsburg, California Supreme Court Chief Justice Roger Traynor, and Judge Frank Johnson have been Sibley lecturers. So too have such academics as Professors Charles Allen Wright, H.L.A. Hart, Grant Gilmore, Stanley Fish, Akhil Amar, and Gerald Gunter. Former President Jimmy Carter has been a Sibley lecturer, as has been Rex Lee and Wade McCree, each of whom was Solicitor General of the United States at the time they delivered their Sibley Lecture. The Sibley Lecture series is underwritten by the Loridans Foundation in Atlanta, now headed by Robert Edge, a senior partner in the law firm of Austin & Bird. The Loridans Foundation has been a generous supporter of the law school and its educational programs for many years. Since the establishment of the Sibley Lecture series, the foundation has contributed well over $1 million to our school. And of course, we are extremely grateful to the foundation for their support of and confidence in the School of Law. The Sibley Lecture series honors the memory of John A. Sibley, a member of the law school's class of 1911, who was very prominent and successful in both law and banking. He was the longtime general counsel to Coca-Cola and represented it in important trademark litigation in the 1930s. For many years, he chaired the board of the Trust Company of Atlanta. He also was a senior partner in the Atlanta law firm of King & Spalding. Mr. Sibley, whose portrait, by the way, hangs on the second floor of the law school right outside classroom F, was also influential in public and civic affairs. In the late 1920s, he played a major role in the campaign that led to the construction of this building, and he was an important player in the effort to obtain full accreditation of the law school in the 1930s. In the 1960s, when many in Georgia fought desegregation and sought to shut down our public schools, Sibley chaired a commission appointed by Governor Ernest Vandiver that conducted hearings throughout the state and urged a calm approach to the issue. That effort laid the groundwork for the state's largely peaceful transition to racially integrated public education. John Sibley died at the age of 98 in 1986. To introduce the latest in a long line of distinguished speakers in this series, it is my pleasure to call upon my colleague, Professor Margaret B. Sachs. Professor Sachs is the Robert Cotton Austin Chair in Corporate Law. A graduate of Harvard's Law School, she joined the faculty of the University of Georgia School of Law in 1990 and teaches courses in securities law, and corporations. Her principal academic interest is in the area of securities litigation, and she has authored numerous articles and co-authored a case book in that area of the law. Please join me in welcoming Professor Sachs.
I am very pleased and honored today to introduce the 107th Sibley Lecturer, Professor John C. Coffey, Jr. Professor Coffey is the early professor of law at Columbia Law School and the director of its Center on Corporate Governance. He graduated from Yale Law School and then practiced law at Cravath, Swaine, and Moore prior to entering teaching. He is a prolific and preeminent scholar who has authored numerous influential law review articles and case books. His scholarship extends beyond corporate and securities law to encompass criminal law and class actions as well. What makes his scholarship so distinctive and so illuminating is that it brings to bear multiple perspectives: historical, procedural, theoretical, and practical, to bear on every legal problem. What I and so many others want to know about a legal issue is what Professor Coffey has had to say about it. It is my very great pleasure to introduce to you Professor John Coffey.
Thank you very much, Maggie, and the University of Georgia is fortunate to have Maggie on her faculty. She's a credit to you. Now, before I begin, I want to deal with a small generational gap problem. I have two faces up there. To many of you, frankly, those of you above a certain age, probably 35, they are immediately recognizable as the face of Monopoly Man, a face that you probably dealt with on many rainy Saturday afternoon when you couldn't go outside. To people under that hypothetical age of 35, maybe you don't know quite who he is because the game of Monopoly was never translated into electronic game. Unfortunately, it had insufficient levels of gratuitous sex and violence to interest the younger generation. So be it for the younger generation. Enough experience with the game of Monopoly would have done you about as well as getting an MBA in real estate finance. But I've used that picture up there because it shows two phases of a problem that's dividing the country and divided Congress and has interfered with any kind of really long-term solution. Those two faces show Monopoly Man, the face of investment banking, during the boom cycle when he is receiving what editorials like to call obscene profits. And then over on the right, we have the image of him with his pockets extended, meaning that he's broke and busted and he wants a bailout because, after all, we can't let his bank fail. It's simply too big to fail. And that is the problem we have. The financial institution that is too big to fail but makes extraordinary profits in the good years. Now, what do we do about this? Well, the first thing I'm going to tell you, if this will work, okay, whoops, I went too far. I'm not very good with these blinkers. Let's see if I can get it one more. There we are. My initial assertion, and I have a number of provocative assertions to make, is that systemic risk crises are as inevitable as death and taxes. Now you know where my title comes from. We're going to see it again, and probably when we least expect it, because this kind of crisis only develops when no one is waiting for it and anticipating it. So what do we mean by systemic risk? We've got to focus on how it arises. There's no universally accepted definition of systemic risk, but generally we mean by this a crisis that produces interconnected failures. The key image is the long row of dominoes. Push the first one over and the rest of the dominoes fall. That is the problem of financial institutions now because they have become so interconnected that the failure of one large one may mean the failure of others. And thus we can have a cascade of falling financial dominoes. We saw systemic risk produce this sort of problem in 2008 when a localized problem in the subprime mortgage market, hardly the most exciting or seemingly risky market in the United States, suddenly produced a worldwide financial crisis, and markets around the world were paralyzed, and banks around the world failed because markets were linked by asset-backed securitizations and derivatives into what I'll call a web of interdependency. And that web of interdependency is what makes the problem of systemic risk. There was a time, a simpler time, when a bank failed, and that bank failed. That was it. Now, one bank failure often implies multiple bank failures and a liquidity crisis that can end lending across the country. And when Lehman failed, banks suddenly shut down like clams and ceased lending to the markets generally, producing a threat of an economic depression. Now, what do you do about this? Well, first, I haven't really adequately explained the nature of systemic risk. It's really got three phases, and the public is most familiar with the first. The first phase, a financial institution can simply be too big to fail. Lehman wasn't. It was allowed to fail, and while there was problems, it did not cause the end of the financial world. Citigroup, however, or Bank of America, may be too big to fail, and we can't really estimate what would be the impact if they were allowed to fail because all other institutions may have outstanding claims against them and would be similarly rendered insolvent. Now, a second phase of systemic risk is the financial institution, while not as large as the Citigroup, may still be too interconnected to permit it to fail because many institutions are its counterparties. Now, the paradigm of this is probably AIG, because it tied together many, many financial institutions through the institution of credit default swaps. I'm not going to pause here to give you a 10-minute explanation of credit default swaps, but think of it as an insurance device. And if you were some financial institution somewhere in the world that realized that you'd taken a very large exposure to some kind of risky investment, such as asset-backed securitizations, then maybe you want to hedge that. Maybe you want protection. Maybe you want a kind of insurance against that risk. And what did you do? You bought a credit default swap that effectively insured you against that risk. But it turned out, to the surprise of at least some, that all of those credit default swaps went back to one common seller of financial protection, AIG. And at that point, when AIG was exposed as the only real seller of this financial protection, and all the other financial institutions around the globe, fearing risk, had purchased massive amounts of insurance from it, the consequence of letting AIG fail was that all those other institutions were now facing high risk, and the insurance policy they relied on was now gone and worthless. That required the U.S. government to come in and bail out AIG. All right? Those are the first two phases. And now the third and least recognized phase of systemic risk. Financial institutions may follow common investment policies. As a result, they become too risk correlated to fail. Now, this is the harder concept to explain, but let's assume that there is common shareholder pressure on many financial institutions. They've discovered there's a lot of profit out there in something called asset-backed securitizations. Whatever they are, there's a lot of profit in them, and thus all banks enter this high profit margin field, because if they did not do so, they would come under shareholder pressure, their stock price would fall, and the stock options with which management was compensated would decline in value unless you did what the market wants. And the market insisted that financial institutions go into certain high-profit, risky businesses like asset-backed securitizations. Now, what's the consequence of that? Well, let's suppose that one of these institutions that's invested heavily in this field gets into trouble, as did a certain institution called Bear Stearns. For about 4 or 5 months, it was in serious trouble that the whole world knew about, and to avoid failure, it tried desperately to liquidate all of its, basically, asset-backed securitizations. What did this do? They tried dumping it into a very thin market, and by dumping it into a thin market, the prices collapsed. When the prices of that investment collapse and every other bank has significant investments in them, and you have to write the value of your investments down to the current market price, that's called marking to market, suddenly you too look like you have a lot less assets and you're getting closer to the brink of insolvency. That's the third phase of what I'm calling systemic risk, because the market forces financial institutions into similar investments, similar lines of businesses, and they all get into the same risky field at the same time, and they all suffer a common decline. All right. Now, a little bit more generalization. The Dodd-Frank Act tries to deal with this, and it invests heavily in prevention, regulatory controls, monitoring. All this is desirable, but is it sufficient? So let me sort of generate some parameters and say there are 3 big problems that make the recurrence of systemic risk, I'm afraid, inevitable. The first is inherent bank fragility. The second is what I'll call the regulatory sine curve, or basically the political economy of financial regulation. And finally, cognitive limits. Believe it or not, human beings are fallible, and they tend to miss certain problems. There's always something that sneaks under the radar screen. Now let's start with bank fragility. Banks, and what I'll call shadow banks. Shadow banks include investment banks, insurance companies, hedge funds, other large financial institutions. They face a fundamental mismatch between the short-term character of their liabilities and the long-term character of their assets. This is not a problem that IBM, Microsoft, or industrial corporations face, because the liabilities of banks are basically deposits, and deposits can be withdrawn by the depositor on a moment's notice. All right, so you have very short-term liabilities. Investment banks do the same thing. Their short-term liabilities are overnight liabilities in the form of things called repos or commercial paper. All right? Given that mismatch, there has always been this prospect of a liquidity crisis. And because of that crisis, we've always had regulation in which the central bank stood there as the lender of last resort to advance funds to prevent a liquidity crisis from turning into a full-scale financial panic. We always had that. We no longer quite have it. That's the problem where Dodd-Frank takes us to the brink. All right, the next problem I refer to the regulatory sine curve, or the political economy of bank regulation. Regulatory intensity is never uniform, but tends to relax as the crisis atmosphere fades and normalcy returns. This is the product of great political pressure. Just the 5 or 6 largest banks in the country are believed to have spent several $100 million simply lobbying the passage and modification of Dodd-Frank, and they're not over because Dodd-Frank delegates great rulemaking discretion to all the financial regulatory agencies, where again there'll be intense lobbying. There's behind this lobbying one common claim. And this is the claim that underlies what I'll call regulatory arbitrage. The claim is always, if you regulate us like that, we'll be no longer competitive with our rivals overseas, and all business will flow to London. That was the 1990s, in which a great deal of financial business did flow to London, and as a result, the U.S. deregulated extensively for fear that otherwise even more business would go offshore to escape regulation. Now, London also suffered in this crisis, and they may no longer be the key player in regulatory arbitrage. But there are other names, and the new name is Singapore. And we're likely to see a lot of business go to Singapore because it's very lightly regulated compared with the U.S. and London. Further, the more you insist upon higher capital adequacy standards, the more you are also implicitly restricting lending, because the more capital you have to have as equity capital, then the less that you can borrow. And the less you can borrow, the less you can lend, so that there's always going to be this real tension between how high do we put these capital adequacy standards and how much lending do we want financial institutions to do. We are going to inhibit lending as we raise capital adequacy standards. That's the problem with the regulatory sine curve, and it tends to lead, after a crisis, regulatory intensity rises, but like the sine curve, it falls as we get farther and farther away from that increasingly distant crisis. Next, cognitive limitations. The AIG story is instructive here because AIG, although a very intelligent, sophisticated financial institution, simply never recognized the possibility that its parent could be downgraded. And the moment that its parent was downgraded below investment grade, or below a high level of investment grade, it suddenly was required to post billions upon billions of dollars of margin, which it could not do. And it never thought that risk would come about, but it never realized just how vulnerable it was to the political vicissitudes that move rating agencies to change their ratings. Other problems like that can come. There's always something that goes underneath the radar screen. So this is the backdrop. Now let's just talk about the specific backdrop to Dodd-Frank. As I said, banks have always been characterized by liquidity crises. And therefore, central banks since at least the late 19th century have assumed the role of lender of last resort. That term was first coined by a well-known financial writer in the 19th century called Walter Bagehot. And he said the role of the central bank was to serve really as this lender of last resort who quickly in a crisis separated the sheep from the goats, i.e. the truly insolvent institution from those that were just facing a liquidity crisis, and you shut down the truly insolvent while advancing funds quickly to those merely facing a crisis in order that a full-scale banking panic not develop. For many decades, the U.S. followed that essential policy. The Federal Reserve Bank, and particularly the Federal Deposit Insurance Company, long performed this monitoring role, liquidating some banks but advancing credit to others to prevent a banking crisis, and very little political controversy arose. Before 2008, the last major financial crisis involving a true bank was Continental Illinois, which failed in a classic bank run in 1984, but the rest of the world largely ignored it. Okay? Now, then comes 2008. Now, in truth, I should put a footnote here and say between 1984 and 2008, there was an incident called long-term capital management, which proved prescient. It was a hedge fund that managed to have counterparty relationships with half the world, and the Federal Reserve had to bail it out in order to prevent what looked like an imminent worldwide banking crisis. They did it. While it was a short-term political issue, it didn't cause any massive repercussions. But no one went further and began to recognize this could happen again, and a decade later it did happen in 2008. Now, 2008 has changed everything. It's slightly different. This was not a bank that failed, but a series of shadow banks. Bear Stearns, Lehman, AIG, those are investment banks. They are not regulated or insured by the FDIC. And because they were not, that forced the Federal Reserve to act and use authority that it had never used before to advance money to bail out the counterparties of AIG and several other institutions. Okay, that's the first difference, shadow banks rather than banks. And shadow banks have come to be as important as banks. Second, it was not depositors that we were saving. There was political acceptance of having an insurance system that bailed out depositors. Instead, it was sophisticated counterparties. And if you actually look who they were, the largest group of recipients were foreign financial institutions, many of them Chinese banks, and a well-known, much-beloved small investment bank called Goldman Sachs, which raised some conflict of interest issues. Okay? They were all being protected at taxpayer expense because the Federal Reserve couldn't pass this cost back to the industry. All right? Now, the rationale for all this was that financial institutions were interconnected in a global market, and a major failure implied a cascade of falling dominoes. That's the too big to fail rationale, and that's something that Congress got very angry at. Okay. Paulson, this is referring to the Secretary of Treasury and the Chairman of the Federal Reserve, their market interventions in 2008, 2009 worked, and they spared us from an economic disaster. That at least is my judgment. We had a very different approach taken in 1929 when then Treasury Secretary Andrew Mellon simply refused to intervene. He said, there's no point in getting the central bank in here trying to prop up banks. Let it fall back to its natural equilibrium. He did nothing. And it fell, and we had 10 years of massive frozen depression with no lending and no economic growth. We didn't have that in 2008 because there was an intervention. But there were political consequences because shadow banks, in particular AIG, are not covered by the FDIC's insurance system. The cost of bailing out these firms fell directly on the American taxpayer, who protected financial institutions around the globe, and that proved to be a major political landmine. Populist anger mounted because the bankers earned extraordinary, i.e. obscene profits in the good times, while they expected public bailouts when the excessive risk and leverage they took on produced failures. And that produced a very, very strong reaction in Congress. As a result, this anger led to provisions in the Dodd-Frank Act that, one, stripped the Federal Reserve and the FDIC of their former power to advance funds to financial institutions in order to avert a liquidity crisis, and two, mandated a liquidation of an insolvent shadow bank. This is called resolution authority, under which the unsecured creditors would likely bear the bulk of the loss. In other words, you can't advance money to a bank that's still solvent but tottering in danger on the precipice of insolvency, but you can liquidate it once it is insolvent. You have to wait till it's insolvent before you can act, and that means we have to go to the full-scale crisis mode before we can have the financial regulators begin to advance money. In addition, late in the negotiations, under political pressure, both the Senate and the House deleted a bill that was a provision that was part of the original Dodd-Frank bill. The original provisions set up an FDIC-like model, a private insurance model, just as the FDIC insures the depositor against at least some level of loss of their accounts, and that cost is borne by the industry. They wanted to set up a parallel system for shadow banks. But the conservatives in Congress said, no, we're not agreeing to anything like that. Anything that smells in any way like a bailout has become taboo, and there is no even private industry-funded bailout authority in Dodd-Frank. So here are the influences that affect Dodd-Frank. Concern that stock option-based executive compensation had caused firms to accept excessive risk and leverage. This led Congress to enact provisions adopting the agenda of traditional corporate governance activism. Things like say on pay and access to the proxy statement, ending broker votes. I'll explain those later, but old-fashioned liberal corporate governance got a major boost here of support on the grounds that it would make managements more accountable. Now, it makes them more accountable, but there's still the question of accountable to whom and which way shareholders are leaning. All right, next, populist anger against bailouts led to provisions stripping the Federal Reserve of its former authority to advance funds to avert a liquidity crisis. And that same populist anger led the conference committee to drop any provision that would have set up in lieu of the old system a private industry-funded bailout system that the industry would have to pay for. Well, we've invested very heavily in safety and soundness regulation and oversight, but there's a question of whether that will survive what I call the regulatory sine curve and the natural pressure of lobbying. Okay? Finally, the Lehman bankruptcy caused Congress to try to get away from the bankruptcy system entirely and move to give the FDIC authority to liquidate non-bank financial institutions, i.e. Lehman and AIG, and make sure that the bondholder pays much of the losses. That may be desirable, but it may be a system that produces greater panic because you're going to have firms become insolvent before they can be assisted. And the market impact of that is debatable. Okay. Now, all these different agendas fit together to give us a coherent reform package. The only way to answer that is to ask what really caused this 2008 financial crisis. And I want to give you 3 different scenarios, all of which are credible. No one can explain a problem as big and as massive as 2008. But 3 different stories. First is the executive compensation story. Option-based compensation formulas led financial managers to take on excessive risk and leverage. A moral hazard problem arises. If the CEO can make $100 million in 2 years, why should he worry about the long run? If I got $100 million in my pocket, the fact that these securities we bought or we've sold to others may go bad in 4 to 5 years, that's someone else's problem. That's the moral hazard story. Under this story, the villain is corporate executives who are overcompensated in ways that let them ignore risk and take on excessive degrees of leverage. That's scenario 1. Scenario B, even more important in my judgment, the too big to fail discount. This is the favorite story of financial economists. Because investors do not believe worldwide that very large financial institutions would be allowed to fail, they lent excessively and at a cheap interest rate to the largest firms. Large firms can borrow at a much cheaper rate than smaller banks because the investor says the government will never dare let the large firm fail, and because of that, we are dealing with an implicit subsidy, a subsidy in interest rates that are too low given the level of risk because everyone assumes the government will be there standing implicitly in the backdrop and will bail you out. All right? If you get interest at too low a level, it makes very good sense to borrow too much. That is, if you can get interest in an extreme case that should have been at 8% and you can get it at 2%, borrow all you can of that cheap money, but it gives you excessive leverage. All right? That's the too big to fail discount, and the villain here are investors who assume a bailout will cushion them and thus make reckless loans to financial institutions. All right? Third scenario, I call this the Sorcerer's Apprentice story, but this is really the limits of human cognitive ability. Few really understood the risks in OTC derivatives, and everybody got together and herded around a common expectation that derivatives were really safe because we're really smart people and we're managing this very well. No one really understood, partly because of lack of transparency, the degree to which all credit default spreads in the United States were basically traceable back to AIG, which was guaranteeing all of them. And people also put undue faith in credit ratings, believing this was truly an accurate, objective system. Well, there are problems here about conflict of interest and about transparency, but people didn't appreciate the amount of risk that was there, and more importantly, how concentrated that risk was. So here our problem is a lack of transparency, and basically human beings are fallible. So what do we do about these various things? Okay, if these were the causes of the 2008 meltdown, what's Dodd-Frank trying to do? Well, in perspective, it's trying to do the following. It does authorize limits on executive compensation. What's just happened this month is that most of the major financial regulators have agreed that incentive-based compensation paid to very large banks will be subject to a minimum of a 50% deferral, under which 50% of that incentive-based compensation has to be deferred for at least 3 years to give you a somewhat longer-term perspective. Not a bad idea, useful, but of course there's always the possibility that shareholders may double that executive compensation to make you just as willing as before as a manager to accept risk. So we have a useful step in the area of trying to reduce incentive-based executive compensation. But at the same time as Dodd-Frank does that, it gives shareholders enhanced power over managers in the hopes of increasing corporate accountability. The problem, the unresolved problem here, is which way does increased corporate accountability cut? Does it lead to greater risk-taking or lesser risk-taking? Congress didn't focus on just how debatable that issue is. Now, the next issue, the too-big-to-fail discount. By restricting the ability of the Federal Reserve Board and the FDIC to lend to solvent but troubled financial institutions, Dodd-Frank is seeking to signal to investors that they should not lend cheaply in the expectation of an eventual bailout because that bailout seems to be barred. But will the market believe this signal? There are ways, at least there are arguable ways, that in a crisis the Federal Reserve could still sneak around these restraints and find ways to lend money to avoid major bank insolvencies. Therefore, what will the market believe? Will they raise the cost of capital to large financial institutions, or will they still get a discount over smaller financial institutions? No one right now knows the degree to which the too-big-to-fail discount is going to disappear, or whether it's going to persist in the belief that we will still have the same pattern of behavior. But as long as there's this discount, we are going to have cheap loans made to financial institutions, and that produces an externality. They take on excessive risk, and that risk falls ultimately on the whole society. All right. Now, the Sorcerer's Apprentice story, I'll cut a little bit of this out and just tell you that we have tried to reorganize the over-the-counter derivatives market both to increase transparency and to mandate the use of clearinghouses. Clearinghouses are a way of getting the industry behind each trade, so if an AIG fails, the whole industry has to pick up the cost, and that whole industry might monitor AIG better than it was capable of monitoring itself. But the problem in doing this is while clearinghouses are a very good idea, they do take credit risk out of the equation, clearinghouses inherently concentrate risk. They mean that one institution is now bearing the entire risk of a failure in the derivatives market. And a clearinghouse failure would be the financial equivalent of a magnitude 9 earthquake, 9.5 earthquake. And that risk is real, and it's one of the ones that keeps people most nervous in the financial community. Okay? So, let's go through each of these 3 scenarios in terms of what has been done and why it may not be as simple a remedy as they propose. Shareholders naturally pursue wealth maximization, and in so doing, they tend to ignore externalities. I don't think I'll shock you in saying that maybe corporations don't give all the attention they should to things like pollution because the costs don't fall on them, they fall on the ordinary citizen. Therefore, it's a cost they can externalize and they don't give it the same attention. Well, systemic risk is partly an externalized cost as well, because the cost falls on the broader community, the taxpayer, and thus it may get underweighed by the actual financial institution. All right? And since the fastest way to increase your profitability as a financial institution is to increase your leverage, we are going to see a continuing tension between regulators and financial managers over how much risk and leverage you can assume. Now, in that tension, Dodd-Frank gives power to shareholders. But is that a good idea, or is that more debatable than it first seems? Well, because shareholders are diversified. They own a broad portfolio of stocks, whereas managers are inherently overinvested in their own firm. That's where their stock options are. That's where their career is. That's where their human capital is. managers have historically been much more risk-averse than shareholders. To the extent we give shareholders greater power over them, we may be giving shareholders greater power to push management in the direction of more risk-preferring behavior, making them closer to being risk-neutral, as shareholders should be if they are fully diversified. Moreover, shareholders know that if there's a discount here, if there really is a too-big-to-fail discount under which banks get money too cheaply, gee, we should exploit that. We should borrow all we can of cheap money and don't worry about what the government should be doing. Let's just take the cheap money while it still lasts. All that means that shareholders are inherently on the side of pushing towards higher leverage and greater risk-taking. The empirical evidence, which I don't have time to take you through, tends to support this view. In a series of papers, René Stoltz and his co-authors looked at financial institutions around the world and how they did in the 2008 crisis. And the bottom line that he finds is that banks with CEOs whose incentives were better aligned with their shareholders, who had been compensated to make them do what shareholders wanted them to do, their banks performed much worse. They failed to a far greater degree in 2008. And banks that the market favored in 2006, which was the peak of the boom period, they did especially worse in 2008, and vice versa. The ones that did poorly in 2006 suffered far less in 2008 because they were a little less leveraged, a little less risk-preferring. There have been similar studies by 4 or 5 other scholars that I've summarized elsewhere, but they produce the same finding, that shareholder-friendly banks do well in booms but much more poorly in crises. And the implication here is the more shareholder-friendly the governance structure of the financial institution, the greater its exposure to insolvency in a crisis. The implication, which isn't purely proven, this is an inference, greater shareholder accountability for at least financial institutions may have unintended and even perverse consequences. It may do what shareholders want, but shareholders want greater risk-taking when society wants, at least banks, to be more prudent and more risk-averse because all of us are on the line as the ultimate guarantors, at least based on recent experience. All right. Now, I'll just economize on this a bit. What's happened under Dodd-Frank is that new powers have been given to shareholders to nominate directors at low cost and put their candidates for directors on the corporate board. The SEC has adopted a new rule, 14A11, one that I very much support in the case of industrial corporations, but I worry that financial institutions are different. And there we don't want to give them the same incentive to do what shareholders want because shareholders generally want more leverage and more risk. All right, this new rule is currently on hold. It's been adopted, but there's litigation going on in Washington in front of the D.C. Circuit, so we'll see whether it's upheld. I think ultimately it will be upheld. This allows activist shareholders to change the population of the board of directors at low cost. Carl Icahn has done this before. He's generally seeking to force the financial institution to take on more risk, to increase its leverage, to sell off old assets, to move out of dull but counter-cyclical businesses. All of that could move us possibly in the wrong direction. Okay? Practically, we don't have time to go through all the broker votes points, but again, it's giving more power to institutional shareholders. And who is the key player in all of this? The key player are what are called the proxy advisors. And there's one dominant proxy advisor, Institutional Shareholder Services, or ISS. Because index investors own thousands of securities, they really can't make individualized decisions in every case. They tend to vote as their proxy advisor advises them to vote, at least unless it's a very public, very much publicized crisis. Therefore, the proxy advisor gains increased power from proxy access and the elimination of broker votes, and may be in a position to push corporate boards and managements harder than they have been pushed in the past by proxy advisors. Okay? Now, let's move to scenario B, the too big to fail response. Dodd-Frank does authorize the FDIC to liquidate a failing financial institution, but not to assist one that's merely troubled or heading towards a crisis. You've got to wait till you're dead before we can bail you out. And the goal here is to not bail out the bondholders, to make them suffer more than they've suffered in the past, to end the too big to fail discount. Now, will this approach work? Imagine that Dodd-Frank was passed in 2006 and that the federal financial regulators realized a year later in 2007, having all the powers of Dodd-Frank, that AIG is doomed because it has taken on excessive risk through what are called credit default swaps. And again, I'm leaving some terminology out. I'm not going to explain credit default swaps. But what would they do? Would they have the nerve, the political courage, to shut down AIG a year before it failed, when it still looked to most of the world to be a fairly healthy institution? Well, there are barriers here. And I'd say the first barrier is the political fallout. Not on my watch is the first response of the White House. If we shut down a major financial institution, it'll look like we failed. We've been in office for 2 or 3 years. It'll look like we didn't catch this in time. We are going to suffer a political cost if you go in there and shut down that institution, and it will sue, and it will get some in the business community to say the government is being arbitrary and capricious. Managers will resist any such shutdown because the Dodd-Frank Act requires the termination of all managers who are responsible for the failure. The next argument will be shutting it down will cause a panic. We've got to find a way to arrange a merger and use federal funds to pay off creditors, which can be done under the statute. But once you do that, you are causing the too big to fail discount to survive because the bondholders are being protected again. Now, what's the likely impact? I think the likely impact is that the political pressures will always move administrations, White Houses, Secretary of the Treasuries, to try to kick the can down the road. Delay it another year or two. Let's see what happens. We don't want this crisis. Now, I say that, and I'm not a student of politics, but let me tell you a story about what's happened in the last 2 months this year. We're going to move now from the U.S. to Ireland. Ireland had a legitimate financial crisis in which the largest bank in Ireland, called the Anglo-Irish Bank, was failing, was clearly insolvent, based on the same things that happened in the U.S., based on the 2008 crisis. And the International Monetary Fund and the Irish government said, yes, we've got to be tough here. We've got to shut this bank down and pay the bondholders nothing, because we're not going to use taxpayer money to bail out all those bondholders who lent way too much to this failing bank. That was the position of the International Monetary Fund and the Irish government itself. The Irish government was moved by the same populist anger as in the U.S. Then appears the European Central Bank, which is the party that had the deeper pockets that was going to be able to afford the bailout. The European Central Bank insisted that the Irish government accept billions upon billions of dollars of lending that the European Central Bank would make to the Irish government, that the Irish government would then lend to the Anglo-Irish Bank to keep it from failing. Why did they do that when the International Monetary Fund was saying you should let it fail? The simple answer, and I'm hearing all this from officials of the International Monetary Bank, maybe it's some bias here, but I think this is the accurate story. The International Monetary Bank heard from the European Central Bank, well, you know, there's an election coming, and this will look very, very bad. And if all those bondholders fail, well, all those bondholders in the Anglo-Irish Bank are the leading banks in Europe. And maybe this will set off a wave of additional failures and additional crises, and we would rather kick the can down the road to avoid another problem. I don't think that story in Ireland is very different what could happen in the United States if you have a choice between a painful termination of a bank, a liquidation of it, and denying the bondholders any or much payment on their claims, or seeking to postpone the crisis until after that election. And there's always an election. They come up regularly, and they produce a desire not to not to get involved in any kind of political crisis. All right, so I'm suggesting that the two big liquidation authority makes sense on paper. I'm not sure that institutions have the political courage to really shut the institution down if you can instead work out some kind of partial bailout, which you can do. Okay? Now, what are the alternatives to resolution authority? Well, there's the International Monetary Fund's preferred alternative. This is really the old-fashioned FDIC model. You have an industry-funded private bailout fund, which would be pre-funded. You would require every major bank to make payments based on their risk-adjusted assets into a fund, and that fund would be there to compensate the bondholders in the event that there was a failure by any large bank or any couple large banks. Economists like this approach because what they say it does is it taxes the externality. I've told you now several times that the externality here is that large banks get money too cheaply and therefore they take on too much debt. If you force all of them to make a pre-funded payment to the private bailout fund, you are eliminating the externality, because when you get the interest rate too cheaply, you are paying the default payment in advance into the industry-funded bailout fund. That's the logic of a privately funded bailout fund, and it's worked at the FDIC and other institutions for a long time. But there are problems. The fund might have to be enormous. The IMF wants it to be something like 2 or 3% of the gross national product of the country, and those are big, big numbers. Moreover, I told you that systemic risk has 3 faces, and the third face is the problem of risk correlation. If the crisis appears, not because of one institution's failure, but because a particular market, like asset-backed securitization, suddenly declines, and all banks at the same time are having a major decline in their assets, no kind of insurance fund like this will be adequate to deal with the problems being faced by a third or half the industry. This is the FDIC, on this IMF idea, is an insurance fund. Insurance works well as long as we're dealing with a risk that is going to be experienced by a small minority of the total population. So death, in a given year, it's going to be faced by X%, but not a very large percentage. If, however, we're dealing with an enormous crisis cutting across all major institutions at the same time, the fund will be inadequate. It's not a way to pool funds to deal with the lone outlier who suffered the crisis. Instead, it's going to be too small to deal with an industry-wide problem. Finally, there is some who believe there's a moral hazard problem. If you have this insurance fund set up, maybe you should now go ahead and take risk because the fund is there to bail you out. At least if you're the only bank that fails, that will work. All right, there are problems then with that approach. I think it's still a good idea, but it's still got problems. Higher capital adequacy. Well, this is something called Basel III. The banks around the world are rushing towards higher capital adequacy under the Basel Committee's direction. The problem with this is, I don't think this is a problem, but I think it's a necessary price, that as we require more capital, we limit the financial institutions' ability to lend. In a depressed economy right now, if you listen to what politicians are saying to banks, they're saying, why don't you lend more? Why don't you get this economy going? Why don't you make much more loans to small businesses? Well, you can't do that without borrowing more, and if you have higher capital adequacy, which requires that your capital be in a certain relation to your loans, you can borrow less and you can lend less, and from a political standpoint, there's going to be much more pressure for more lending than for higher capital adequacy, and thus we're going to see a long fight continuing. There's also this problem that banks seem to stay one step ahead of the regulator. We thought we saw a problem of off-balance sheet financing with Enron. They had billions of dollars of liabilities hidden off their balance sheet, and we thought we had stopped that. Well, we look in 2008, we find that Citigroup has hidden trillions of dollars off its balance sheet in things called special purpose vehicles that were simply there holding huge investments in asset-backed securities called CDOs, or collateralized default obligations. Again, I'm not defining terms, but banks seem to be able to hide liabilities off their balance sheet better than regulators can find them and get the political consensus necessary to restrict that. So higher capital adequacy makes sense, but it's not a panacea. All right. Now here comes a solution that I'm going to push. This is not, however, something that I am the inventor of. This is something that's in Dodd-Frank. It was an idea that got into Dodd-Frank towards the end of the process. Contingent capital is debt that at one or more predefined trigger points converts automatically from a debt security into an equity security. What's the advantage of that? Equity can't default. If you were holding something called bonds, and at a certain objective point when the market price falls enough of the stock, that bond, without you having any choice or any say in the matter, converts into an equity security. Well, the equity security can never cause a default or a bankruptcy. So we're making the company relatively bankruptcy proof. And Dodd-Frank does authorize this. The Federal Reserve can adopt a contingent capital standard for systemically significant financial institutions. However, the industry has a different idea than I do about the kind of standard that might be adopted. What could they do? The Fed could say that a defined percentage of a bank's debt, say 33%, just to give an illustration, would have to consist of a debt security that would convert under defined circumstances of financial distress into an equity security, because that would suddenly change the balance sheet tremendously, and you would no longer be in danger of default because you no longer have as many bonds outstanding. And that protects, when these crises occur, they usually occur in the short-term debt panicking. The short-term debt would have less reason to panic because the longer-term debt on top of them would have suddenly turned into equity. Now, at a minimum, this idea substitutes a pre-planned contractual mechanism for the destabilizing and uncertainty of a major bankruptcy. Even if most large financial institutions together at the same time approach insolvency, which is the problem that I thought crippled and made ineffective the insurance system I was describing earlier, even if that were to happen, this approach can still avert a systemic meltdown because at all of these firms, the debt becomes, or much of the debt becomes an equity security, and thus there can't be a default. Yes, it's painful for the bondholder, but that's part of the point. We want the bondholder to worry about something and to demand a higher interest rate so we're no longer getting the same too big to fail problem. Now, this kind of procedure should work on objective market standards, not based on accounting, because accounting can be manipulated, and not based on the regulatory agency's edict, because the regulatory agency can be lobbied and will be lobbied and may give in and postpone any major conversion. If instead it works on a market price formula, we have a mechanism that I think does several distinct things at once. Let me sort of give you an illustration. Okay, let's go back one. This is an idea that's been supported by many in Europe, Canada's bank regulators, the Swiss, and something called the Financial Stability Board, which is the G20 body that's trying to coordinate overall policy. All of these proposals contemplate that a debt security would convert into common stock probably somewhere near the 12th hour, one step ahead of what otherwise would be a bankruptcy. Excuse me. On conversion, all of this debt converts into common stock, and the common stock would trade in the market and probably be held by the same shareholders as before, the same institutional shareholders. That would not change the pressure on management. We would still have stock being owned by institutions that tend to have incentives favoring risk preference, and they may even become more extreme at this late stage. I would instead say the debt security should convert at a series of incremental steps into a voting preferred stock with a fixed return, cumulative dividends, and voting rights above all. This has two purposes. The holder of such a senior security would have incentives aligned with those of other creditors and would naturally seek to oppose risk-taking and higher leverage. Senior security holders want reduced leverage, not higher leverage. Thus, we don't have the same problem that the debt moves into the hands of common shareholders. Also, if the convertible preferred stock were to be receiving on conversion a higher dividend rate to compensate them for the fact they're no longer holding bonds, then that conversion would be more painful to the common. And that's part of the goal here, to be painful to the common in order to deter excessive risk-taking, because the common shareholders may be the source of some of the pressure for increased leverage, and they have to, under a proposal that starts earlier and has incremental conversions, the common starts suffering pain at an earlier point, and it may deter excessive risk-taking. One goal here is to use voting rights, in addition to the firm's capital structure, to create a countervailing voting constituency to the risk-preferring common shareholders, and thus to create a buffer that may insulate the bank's management from shareholder pressure. But the larger point, we need a fail-safe remedy that does not depend on the wisdom of regulators or on the political contingencies of a particular moment. So long as this is left up to the regulators, they're subject to immense pressure to delay and not take any radical, strong steps. But if we have a contract that says, in the following ways, this security converts into a preferred stock, then everyone knows it's coming, and the market anticipates this, and the common stock gets priced downward as that conversion point approaches. Let's see if we can give an example. Well, okay, here's just a hypothetical formula. Suppose our very big bank, Citigroup, would be required to issue not less than 1/3 of its debt in the form of contingent capital convertible into a voting preferred stock, with a high dividend rate on conversion so that the bondholders don't suffer any dramatic economic loss. Now, 1/3 of this debt security would convert on a stock price fall of 25% or more from the stock price on the date of issuance. Another 1/3 would fall on an additional 25% for a 50% fall, and the last would come at 25%. The whole goal here is to have incremental conversion to avoid the kind of all or nothing decision that may keep regulators from daring to use resolution authority. Having a more modest incremental change is easier to swallow than having an all or nothing decision like whether to put the company into liquidation and resolution authority. All right, it's time to summarize. A final word on regulatory strategies, because that's my real talk. What are the regulatory strategies that make sense? The Dodd-Frank Act invests heavily in regulatory oversight and monitoring, traditional safety and soundness regulation. That's commendable, but here's where I'm going to sound pessimistic. The same people who missed long-term capital management, Enron, WorldCom, the 2000 IPO bubble, Bernie Madoff, Alan Stanford, and the subprime mortgage crisis in 2008 will, believe it or not, miss something in the future too. And if that makes me a cynic, I'm a cynic. For all the reasons that makes humans fallible, we need some more objective standards that automatically trigger a fail-safe remedy, such as this conversion of debt into equity to avoid massive bankruptcy. The key problem with reforms such as resolution authority, which are sound ideas, is that there may never be the political courage to use it. Therefore, what reforms don't depend on political courage? Well, if we were to fund it, a private bailout fund, the IMF proposal, contingent capital, higher levels of capital adequacy. If we do those things, they are not subject to the same problem of relying upon an ad hoc, politically contingent system. Conclusion. The Dodd-Frank Act does work at some cross purposes. It tries to restrict executive compensation, but it also exposes financial institutions to greater shareholder pressure, which will often be short-term oriented and lead to pressure for greater leverage and risk-taking. It denies regulators their former power to deal with liquidity crises, and that's dangerous. That's a financial straitjacket that forces you to wait for liquidation and then have this major event rather than an earlier advancing of short-term capital. It expects them to liquidate failing financial institutions, but that's politically very costly, and it's not at all clear that any administration will want this to happen. It does not provide for a private bailout fund, and it depends on regulatory oversight and omniscient regulators. It will work for a time. I'm not saying there's going to be a crisis next year, but that regulatory sine curve will return, and that implies that eventually oversight will relax over time, and then. You're hearing from me a pessimistic message. You can count on the Treasury Secretary and the Federal Reserve to tell you in future weeks and months that we've solved the problem, Dodd-Frank has worked, and systemic risk is no longer a great threat. But the systemic risk crisis is like death and taxes. It will reappear, and I think we need some other mechanisms, which are actually there. Contingent capital is there in the Act. It's up to Congress, up to the administration, whether to define it aggressively or simply use it as a last-minute 12th-hour alternative to bankruptcy. So that's where we are, and I'm sorry if I'm giving you a somewhat pessimistic message, but thank you for listening to me. Okay. You want to call on questions? You want to ask for questions? If I haven't put you to sleep, I'm happy to take questions. Over here. And speak up. I'm really bad hearing.
You talk about systemic risk and you know, in the context of death and taxes, it's going to be with us regardless. And I think it's hard to put in those contexts, you know, particularly with this financial crisis, because we had lots of these financial institutions creating these financial products and then selling them to people and betting against them. So they obviously knew that these products were risky. They knew that there were problems inherent in that. They lobbied for many years to get things like Glass-Steagall taken away and eventually fully repealed. And, I mean, this is what happened with regulated and getting things regulated, then we had massive health crisis. So there's very definite, there's a definite trend of people, trying to get rid of things like very strong regulation, of going for greed, essentially. And so it doesn't seem so much inevitable as it is something that we don't want to talk about. We don't want to talk about the fact that people are putting themselves in a position to make money off of others in this way by selling them a CDO and then betting against it.
Well, I don't want to excuse all the people who, I don't want to excuse for a moment the credit rating agencies or some of the real estate brokers who sold worthless, toxic loans that went into portfolios. But what really happened in the 1990s was we experienced massive financial deregulation under the pressure of international arbitrage. We passed a statute in 2000 that took all authority over over-the-counter derivatives away from both the SEC and another body called the CFTC, the Commodity Future Trading Commission. That happened because the industry convinced Congress that business was going abroad and they had to let American firms compete, unimpeded by any financial regulation. Financial institutions unimpeded by any financial regulation sooner or later fail. And that was part of the problem. There were bad guys, there were villains, but the arguments about international arbitrage led to the whole over-the-counter trading, over-the-counter securities markets, the credit default markets, all to become totally unregulated. That was a political decision based upon fear that business was going abroad. That's part of my regulatory sine curve. We will see things like that happen again. It may not be going abroad to London. I think it'll be going abroad to Singapore, which is busily seeking the business right now with much less regulation. So that's the problem of reduced regulation will produce more and more risk-taking, some of which may be corrupt, some of which may just be innocent. Now, bad as many banks were, remember that someone like Citicorp shows the real human dilemma here, because while one side of Citicorp is marketing very risky asset-backed securitizations, another side is buying them in tremendous numbers and putting trillions of these things into their off-balance sheet funds because they believed in them. Very large financial institutions often are characterized by the phenomenon that one hand doesn't know what the other hand is doing. And the real failure of Citigroup came because it had trillions of these kind of CDOs held in off-balance sheet vehicles, which it guaranteed to everyone else. So it had written these extraordinary guarantees on financial instruments that if they knew what the investment banking arm knew, they might think were shaky. But the asset management arm didn't know that, and I think that will continue within large financial institutions. There will be people acting at cross purposes, and I think that's what caused the failure at a number of financial institutions. They really were investing in stuff that they shouldn't have been investing in, and that wasn't because of fraud. That was because they also bought the same scenario that you could rely upon financial technology and credit ratings. We now know that credit ratings are suspect, but there'll be something else that will be problematic in the future as well. So I'm just saying that I think the problem will be there. If there's a change over time, it's also the change that we live in a much more concentrated financial system where everybody is linked through the new technology of financial derivatives. And that means that there are going to be counterparties at risk any time a major institution comes close to the line of failure. That wasn't there back when we didn't have derivatives. But I think derivatives are here to stay. I don't think you can eliminate them. I think you can only try to regulate them intelligently. Okay. Over here?
To what extent is there actually a market running demand for these contingent capital securities? I mean, I think some of the larger European banks have tried to issue contingent
There have been two issuances so far by Lloyd's Bank, which was really, it was able to force its shareholders because otherwise it was going to fail, and so you can issue things under those kind of pressure. The Swiss have ordered it. Switzerland is the unique country. It has banks that are not only too big to fail, they are too big to save, because UBS and credit default are bigger than the Swiss economy, each of them. So they are requiring a very large amount of contingent capital because they know there is no way they could ever bail out. They're just too small a country for the size of their banks. European banks are somewhat more financially leveraged than U.S. banks, and I think they are responding to this. In the U.S., there is a willingness to use contingent capital, but only a willingness to use this as a 12th hour way of averting formal bankruptcy. I think to get the real impact of this, it's got to be a more marginal, incremental conversion from the point in which you start showing distress by having your stock price fall. And I want to use an objective measure, because if we use accounting will always be manipulable, and if we use regulatory edicts, they get lobbied. So the stock price is a pretty objective measure. I think things like that will work. The Federal Reserve has to come forward with a report on contingent capital in the year 2012, next year. And it'll be a debate between the activists who want major use of it and the industry that is happy to see it used as an alternative, as a kind of prepackaged bankruptcy plan. So we won't see people resist it. We'll see people define it differently. Okay? I think your hand was up.
It was kind of a related question. So is there a danger, in terms of who buys the contingent capital, that there be the same interconnectedness, that we see political pressure if, you know, if there's widespread purchase of the contingent capital, stock prices start to drop across the board, and then you feel like there's political pressure for a bailout because otherwise there's going to be...
But remember, the stock price will start to drop well in advance of the moment of conversion, because the market will see this. So it won't be the sudden abrupt, you can't let this happen, the market will collapse. The market price will go down as the well-known, publicly disclosed moment of conversion would arise. And at that point, there won't be the same cataclysmic impact. So I think you have a more gradual transition, and one of my premises here is that a very sharp transition produces immense political lobbying on the grounds you can't let that happen. And the good thing about markets is if the market knows it will convert at a certain point, the common stock will fall in anticipation of that conversion. So it's a more marginal change. You will get resistance, yes. And the resistance will be in terms of defining contingent capital very narrowly. Okay? In the back?
The OTC market kind of had its impact on...
A little bit louder, can you?
The OTC market kind of had its impact on the financial crisis because it caused like an inefficient system of risk sharing. So why has it been more like push from Congress or from Washington to standardize these OTC contracts?
I'm not hearing what you're saying. What can the SEC...
Why are they pushing like more less standardizing like to prepare for false?
Well, I mean, right now the SEC lacks a budget. And they won't have a budget until they can convince a very conservative House of Representatives that they want them to have a budget. So their ability to lead any reform now is extremely politically constrained. This is why I always come back to political constraints make cowards of us all. And the SEC was instructed to set up an office to monitor credit rating agencies. They aren't doing it. They're saying they don't have the budget to do it, but they also know that Congress doesn't want them to do it. So there are a lot of things that are authorized that aren't being done because there is extraordinary moment of political division in the U.S. Congress, and agencies like the SEC don't have the day-to-day budget to do anything right now, and therefore they are cutting back and pulling their punches in some areas. The SEC is not the principal regulator. It's the Federal Reserve and the other members of what's called the FSOC, the Financial Supervisory Oversight Council, which is about 10 agencies, that will determine things like what to do on contingent capital. The SEC is doing things on executive compensation, which I think are desirable, but they're doing them absolutely in lockstep with 6 or 7 other regulators. Okay? Over here. A little bit louder, though.
Back to, I think she was asking about the stock market. I'm not sure how it relates to what we spoke about today, but it suffers, like it's susceptible to corruption. And one of the issues, many companies own such a large amount of stock that they can run algorithms and sell their stock and change the price of the value and then rebuy them at a lower reduced rate. And I was wondering, is there anything like the Dodd-Frank Act now that would suffer all these economic crises that were regulated?
Now, the Dodd-Frank Act has really almost no new litigation remedies. You were talking about how can we sue these people to stop them. The only way it creates a new litigation remedy is in the area of credit ratings. And by the way, I wrote that provision. I think it's a good idea, but it's a modest idea. It doesn't have a day or night difference. And you can only sue, credit rating agencies are not big players. They can only be sued so much before they would go under. There are no new criminal penalties. Sarbanes-Oxley 8 or 9 years ago had all kinds of new criminal penalties. They're not here. They're not new litigation remedies. There were proposals. I would like to see, if you ask me what would change things, I would like to see us restore the idea that those who aid and abet a securities law violation can be privately sued. that would extend private enforcement against the professionals. When you look at something like these various exotic over-the-counter derivatives, the real key players are the investment banks, the law firms, the accounting firms, the credit rating agencies. They can't get sued because they're only aiding and abetting the violation in most cases. And this is a result of a Supreme Court decision in 1985 called Central Bank of Denver. I think you would get the professionals more nervous and less willing to, let's call it, acquiesce in dubious behavior. I'm not saying they're committing outright fraud, but they are acquiescing in dubious behavior because they are immune from private litigation. So I think private litigation would make a difference because it's profit-seeking and doesn't need a budget from Congress. But that would require a change that even in the strong reactions we had in 2008, there wasn't enough support. We fell about 15 votes short of the attempt to get Central Bank of Denver overruled and reestablish private liability for aiding and abetting a securities fraud. But I think that would be useful because it's the professionals that you need the cooperation of to pull off something like this. Okay? Anyone else? Over here.
Do we have some estimates of the legal costs of compliance?
With what now?
Regulatory compliance.
Well, I mean, all of these things that are in this act, all these things that are in this act are going to have significant costs. And of course, unregulated financial institutions tend to fail. That's also a cost. The lawsuit that I mentioned earlier, there's something called proxy actus, which I didn't really describe in any detail. That's being sued in the D.C. Court of Appeals right now by the Business Roundtable, which is saying the SEC, in promulgating this new proposal, which Congress had authorized, said, SEC, you can do this, but the SEC did not conduct an adequate cost-benefit analysis in the view of the Business Roundtable, and they're suing about that. So that in terms of legal weapons, cost-benefit analysis becomes a major weapon for defendants to say you can't do this because you haven't done an adequate analysis. Each of these different reforms are different. I don't think it takes that much cost to raise the level of capital adequacy. You can just promulgate a rule. What it will do is have a great deal of impact on behavior. You will probably make less loans. Okay, so all I can do is talk about it on an individual one. I can't say all of it, but certainly there are costs, and certainly there were trillions of dollars in losses the taxpayer bore in 2008 because of underregulation. You can well tell me that there are areas in which there'll be overregulation. There were many things done in Dodd-Frank that I think are either irrelevant or marginal. That's because political coalitions come together, everybody has their own agenda, everybody gets to tack their own reforms onto the bill. So there's a lot of junk in Dodd-Frank, but that's generally not a problem of constitutionality. Okay? Anyone else? One last question over here, I guess.
You talked earlier about the populist anger and how this spurred the bill. A lot of that, it seemed like in 2008, had to do with people losing their 401ks that were chopped in half, annuities not being instruments they had to retire on. What do you think systemic risk is doing to the psyche of the American investor?
What do I think? What? Now, to summarize that in a sentence.
What do you think the systemic risk and the awareness of this is doing to the psyche of the American investor, and would your equity conversion idea change that at all as far as long-term instruments?
Well, the idea of this equity conversion is we prevent there from being a highly symbolic and panic-creating failure. We are causing a cost. The common shareholder, when that debt becomes equity, he's diluted, and if that debt were to become preferred stock, he's subordinated to it. He's going to lose a lot, but we're not going to have that panic-creating event of a major bank failure. And that's always the problem that has scared administrations that, gee, what would happen if there was a major bank failure? When Lehman failed in 2008, lending shut down overnight all across America. Every bank said we've got to get all the assets we can back into the vault so that we can avoid any kind of liquidity crisis, and no one could borrow a dollar. That's the kind of consequence if you have a panic-creating event. A conversion is far less likely to do that than an actual default. I'm not saying there aren't costs. The idea of this is to try to put more of the cost on the common shareholders because they may be the source of pressure. And it's also true, we talk about, the economists always say the best approach is to tax the externality. There are really two ways to do that in terms of the reforms I've been talking about. One is the private insurance scheme where the industry has to pay up front a very large insurance premium to the common fund. The other is to use contingent capital because the creditors who buy it will require a higher interest rate. If you have to pay a higher interest rate on your debt capital, that is going to compensate and offset the cheaper money that you may have gotten before by those who are making other kinds of loans to the company. We have to find one way to tax the externality, which this is the consensus view of economists, is that the too big to fail scenario has produced too much leverage at too low a cost without the real cost being absorbed by the financial institutions and instead flowing through to the taxpayer. Okay? Thank you.
Please join me in thanking
Okay.
Professor Courtney.